There is only one reason for which the court can grant you a divorce, and that reason is that the marriage has broken down beyond reconciliation. I explained to you what that means in law and what facts can constitute or can lead to an establishment that a marriage is broken down beyond reconciliation. I'm Godwin Selassie Dapo, and this is Make It Legal.
Make it legal.
When you are a party to an ordinance marriage and there are issues to the marriage, and then you ever decide that you have to end it all, you have to go to court and have the marriage dissolved, I want you to be guided by these principles of law. When you go to court, this is how divorce plays out, and this is how the court finally comes to agree that your marriage should be dissolved. I want you to pay a close attention, because knowing this can help you avoid these things I'm going to talk about if you truly want to avoid divorce. And then it can also put you on guard to know that this is the risk you are putting your marriage to, or you are likely to experience divorce should these things be happening in your marriage. The only reason why the court will grant a divorce for an ordinance marriage in this matter is when the marriage is proven to have broken down beyond reconciliation. It means that from all indications, all efforts put together to ensure that the two of you resolve your differences and live together happily ever, if all of those fail, the court will say that the marriage has broken down beyond reconciliation. It means that the parties are unable to resolve their differences. They just couldn't come to terms to agree to resolve a dispute that is between them. Maybe family members have tried, colleagues have tried to advise, pastors have intervened, but they have not been able to agree that we are letting go all of these issues that are separating us, or that are putting our marriage down there. We are putting it aside and enjoy the marriage. They are not able to agree. And if that happens, the court is compelled to dissolve the marriage on certain grounds. Now, how do you prove that a marriage is broken down beyond reconciliation? How do you prove that? What and what do you bring to bear for the court to accept that indeed the marriage is broken down beyond reconciliation? I'm sharing 5 of those facts with you that if they are established, the court will declare your marriage to be dissolved. The court will say that this marriage can be dissolved. In other words, the court can grant divorce for that marriage. When you know these facts, you are able to guide yourself and avoid them, because you know that when they show up their faces, it's a basis for the court to say that the marriage has broken down beyond reconciliation and therefore should be dissolved by the court. The first fact which the court will rely on to say that the marriage is broken down beyond reconciliation, and as such divorce should be granted, is that either spouse of the marriage has committed adultery. And then by reason of the adultery, the one who sends the case to the court cannot live with the other person as a husband or as a wife again, and therefore he wants a divorce. What is adultery in the first place? Now, adultery is very simple. When you are a married person who marry under the ordinance, I should be specifically clear on that. When you marry under the ordinance, you cannot have sexual intercourse with another woman or another man outside of that marriage. As far as sex is concerned, it's only you and your husband and you and your wife for life. If you go outside the marriage to have sexual intercourse, it's called adultery. When that happens, that adulterous act can be evidence that the marriage has broken down beyond reconciliation. If the petitioner, the one who sends the case against you, your husband or your wife, says that because of that thing you have done, I cannot live with you, I cannot tolerate you in the same house and call you a wife or husband, and therefore I want the marriage dissolved. Now, these are some of the things you should know. If the adulterous act was committed 6 months ago and the respondent or the petitioner did not complain about it, or did not leave the house, or was able to stay in the house for more than 6 months, the court will say that, oh, petitioner, you are able to live with this. That is why you are staying with him beyond 6 months. But if you stay for just 2 weeks after the adulterous act, and then you leave the house, you find it intolerable to stay with the person because he's done that, the court will say that, well, having looked at the fact that when he or she engages in that act, you could not stay with him more than 6 months. It is true, you can rely on that act and say that it is an adulterous act that can constitute a ground for saying the marriage has broken down beyond reconciliation, and as such, divorce should be granted in that matter. Now, in most cases of divorce where the basis of seeking dissolution of marriage is that the marriage has broken down beyond reconciliation and the parties are alleging adultery, the rule is that you have to prove the adulterous act, and most times it is proved by producing evidence of a past sexual intercourse. And some of the evidences will be an obvious one, which is pregnancy with somebody else. So if the woman is pregnant for somebody else and the person who she's pregnant for is not the husband, obviously she has committed adultery. If the man also has a child with someone else, once the child belongs to him, then it means that he has sexual intercourse with that other person. And even though the child may now be 6 years, 7 years, 10 years, if the woman just gets to know of the fact that he has a child with someone else and it is not yet past 6 months, she can rely on the act that she's now aware that the man has another child with somebody else and she's not able to tolerate it. She's not able to live with the person. She can go to court for the dissolution of the marriage. Once she stayed more than 6 months, the court will say that no, you find this tolerable, you can live with it. That's why you didn't actually take steps to dissolve the marriage. So we cannot rely on that act to dissolve the marriage. The second fact the court will be expecting you to prove to show that the marriage has broken down beyond reconciliation is the fact of unreasonable behavior of either party to the marriage. Now, that is something that you need to pay attention to. It's often the common ground we see in most cases where people want divorce. Unreasonable behavior. When you are a married man or a married woman, you are expected to put up certain behaviors, especially towards your other party or partner. If you don't put up a behavior which is reasonable in law, the court will say that because of that unreasonable behavior, will dissolve the marriage. Now, the common ones we often see are where either the man or woman is a drunkard, excessively drinking. It could be an unreasonable behavior to the marriage because the other party doesn't find it reasonable and doesn't find it tolerable. The court will say that that conduct of yours, excessively engage in alcoholic drinks, is interfering with the peace of the home, is creating an embarrassment for her, and she cannot live with you as a husband. She cannot be expected to live with you as a reasonable wife or reasonable husband. The court will say that, okay, that behavior is unreasonable of a husband, of a wife. Therefore, the marriage can be dissolved. Maybe you've been flirting with a house girl. That is quite unreasonable of a husband to be doing in the house. So the court will say that it's an unreasonable behavior of the man, and it can be a basis for dissolution of the marriage. And the common ones we often see also is where the man unreasonably beats the wife. If the man continues to beat you because he thinks he's older than you, can just, slap you anyhow, beat you anyhow, and all of that. If he engages in any of those acts against you, they are unreasonable acts. We don't expect the husband to be beating the wife. We don't also expect the wife to be beating the husband. So none of these things should be happening. If they happen in the marriage, the court will say that no, it is an unreasonable behavior of a husband or a man. And the court will look at everything and say that, yes, it is true. Maybe this man cannot reasonably be expected to live with that woman who is behaving in that particular way. Therefore, we're going to dissolve the marriage. They could say that this woman cannot reasonably be expected to live with that man who is behaving this way. And then it is fair to dissolve the marriage. The third fact, which can form the basis of divorce in court, or which can form a basis for the court to establish that a marriage has broken down beyond reconciliation and should be dissolved, is that for a period of 2 years continuously, both of you have not lived as husband and wife. You have been married and have been living together for 10 years. All of a sudden, one person leaves the house, never comes back. We don't hear from him, and it's been 2 years continuously. Not that he leaves the house and after a month he comes back and stays for 6 months and leaves again, come back and stay for 1 week and leaves again. Not that one. No, we mean for continuous period of 2 years, he has deserted the home. He just left and probably told you, I'm stepping out and come. Then he never comes back for 2 years. The one who remains in the house can go to court after the 2 year period and say, you know what, we've been married, but this man deserted me for 2 years continuously. And as a married man or married woman, I'm married because I want to have a companionship with a man or woman. But he or she just got up and left the house and deserted the home, left the children on me, maintenance of the home, and the kids were all on me. It's not a good behavior. And because of that, I think you should dissolve the marriage on grounds of desertion for a continuous period of 2 years. So if you are deserting your home for a period of 2 years, remember you put your marriage in danger or the risk of divorce. The fourth fact, which can form the basis for the court to conclude that the marriage has broken down beyond reconciliation and divorce should be granted, is that the two of you have deserted each other for a continuous period of 2 years and the other party consented to the dissolution of the marriage. He has been away for 2 years and he says that, you know what, I've not been able to come, and it's like the marriage is not, moving on. We don't know what's happening, and I agree that go and dissolve it. Once he's aware of the implications of the consent he's giving, and he has given the consent, the court will go ahead and dissolve the marriage. Remember, the first one, there is no need for consent. You just have to go and prove that for more than 2 years now, continuously he has deserted the home or she has deserted the home. Once that is established, the court will grant you a divorce. That is the third point I mentioned. But this one is where there is still a continuous period of 2 year desertion, but you're also saying that he does not mind for the court to grant us a divorce. He is agreeing to it. Now, don't you think these provisions are no longer going to be very applicable, especially in the age of technology, where although the man or the woman is not home for many years, the parties have been communicating? Oftentimes the challenge comes in where the desertion was not a planned one. The man is not aware that the woman is leaving the house. The woman just left the home and stayed with somebody else somewhere, and for 2 years she's not been home. The marriage cannot survive. Maybe the woman just left home, and just because of some fight or quarrel, she left the home, and for 2 years she hasn't come back. She doesn't pick the man's call. They don't interact, and the man can say that, dissolve this marriage, let me move on with my life, because the person I've married for 2 years deprived me of companionship and of the privilege of marriage and having a woman or man at home with me as marriage permits under the law. So dissolve the marriage. But what do you think? Do you think in the age of technology, these rules can still apply? Or once people are away for more than 2 years and they are still in touch with each other, communicating effectively and behaving as though they are together by the aid of technology, it's fine. Everything should be okay. It's consensual between the parties, and it should not be a ground for grant of divorce. I think I can agree with you, but what do you think? Share your view in the comment section. Let me read and know what you think. The fifth fact I want you to note is that when the two of you have not lived together as husband and wife for a continuous period of 5 years, the court has said that, you know what, one of you can petition for the marriage to be dissolved. There are interesting cases where couples get angry with each other and say they don't live together, but they live in the same household, but they have separate rooms and separate arrangement for feeding. Nobody comes to each other, but they live in the same household. Will you say that those couples have deserted each other for 5 years? What do you think? If they have not been together for 5 years. Now, the law is that they should live together as husband and wife. So if you are in separate rooms, in separate places, and eat separately, are you husband and wife then, or you are just co-tenants? I mean, that is not the law. So the law is that if you don't live together as husband and wife for 5 years, it can be a basis for dissolution of the marriage. Or it can be evidence that proves that the marriage has broken down beyond reconciliation. The sixth one, and which is the last one, but certainly not the least, is that both of you, after diligent effort at reconciling your differences, you were unable to reconcile them. So where you have differences that you have tried and tried and tried, made all the diligent effort to ensure that they are resolved, but you are not able to settle them or reconcile the differences, the court can say that because of these irreconcilable differences, or despite all effort to resolve these differences, you have not been able to, it can be a basis to grant a divorce. Remember, the court will always expect you to prove that you have made attempts at reconciling the differences, at seeking resolution of the conflict or the issues in a marriage, but you were not successful at getting a resolution. It is just not working, and you want the marriage to be dissolved between the two of you. Sad, but if it is proved that you are unable to resolve the differences, the court will go ahead and say dissolved. Okay, so why do you need to know all of this? Is it because I want to encourage you to pick on few differences and issues you have in your marriage and say you want a divorce? No, I don't want you to dissolve your marriage. I want your marriage to live on. I want your marriage to flourish. I want society to benefit from the beautiful marriage you are having now. I want we the younger ones who are married, who are yet to be married, to learn from the exemplary marital life you have. So I want your marriage to continue. I want you two to flourish together. But most importantly, I want you to know these things so that you don't fall victim to them. You should also know them because you need to know that when you engage in any of the things I've spoken about, you are putting your marriage at risk of divorce. Remember, when you engage in adultery, when you engage in unreasonable behavior, when you just desert the home anyhow, when you engage in all kinds of minor conflict that you refuse to settle or refuse to seek resolution to, it can degenerate into bigger issues that can put the marriage at the risk of divorce. You have the option to resolve your differences when they occur. You have the option to seek help whenever issues occur. The last option you should always consider is not just to rush to court, but it's to again seek resolution. When you are done seeking resolution, again try to resolve it. When you are done trying again, make a last effort again. If you've done all you can and all God can help you do and it doesn't work, just know that this fact will be required of you before divorce will be granted at the end of the day. I want to believe you like the video and you are happy to have watched and learned some few lessons. Just get a few friends to subscribe to this channel and get them to watch the video. And when they are done, please share it to a friend, share it on your WhatsApp groups, share it on Facebook, share it to friends and families. Let them get to know. Let it be a tool that could guide them, avoid the things I mentioned. I am Godwin Selassie Dakpo, and this is Make It Legal.
Make it legal.